Welcome back. Good afternoon, colleagues. It is still Tuesday, March 14th, and we are on voting list number 13. We're going to start with some bills. We'll start with some bills that Patrick has. So Patrick, where do you want to begin?
Let's start with Senate Bill 90, which is the last bill listed on page 1 of the voting list. This is the bill that establishes consumer protections relating to telephone solicitations to residents of the state, unless prior express written consent is provided by the called party. The bill prohibits a person from making a telephone solicitation that involves an automated system for the selection or dialing of telephone numbers or the playing of a recorded message when a connection is completed to the number called. It also restricts the methods, times, and identifying information that a solicitor may utilize, such as prohibiting calls between 8 p.m. and 8 a.m., making a solicitation of more than 3 times to the same called party during a 24-hour period on the same subject matter issue, and concealing the true identity of the caller by using technology that displays a different caller ID number than the number the call is originating from. You've got a reprint in front of you that I can just walk through and highlight a few things. So there's an amendment that clarifies a definition in the bill on page 3. And then there are some places where the bill has been restructured. So it looks like there's all new text here in the amendments, but actually they've just been moved to a different place in the bill for organizational purposes. So on page 4, there is a broader exception for business to business sales where the telephone solicitor has been lawfully operating continuously for at least 3 years under the same business name. And all these things listed, all these items listed here are the types of solicitations that would be exempt from the bill. In addition, if you look down to 5 and 6, exempt from the bill would be a single telephone solicitation made to a customer or client in response to an inquiry or request from the customer or client, and a communication between a business and a customer that have an existing business contract or relationship with each other. This is in response to some testimony and requests from the chamber and from some of the Chamber of Commerce and the insurance producers. Also exempted from the bill under these amendments would be a non-commercial telephone solicitation for the purpose of public opinion research, including polling on behalf of a political campaign. Just going through the bill, the next page, some more provisions have been relocated in the bill. And if you go to page 6, there's some clarification regarding the rebuttable presumption that a telephone solicitation made to any area code in the state is made to a resident or a person who is reasonably presumed to reside or have a place of business in the state at the time the call is made. And then the amendment would push back the effective date of the bill to January 1st, 2024.
Okay. Are there any questions on Senate Bill 90 or its reprint? Senator Giles, then Senator Bidle.
Yeah, thank you, Madam Chair. What's the penalty for a violation of this?
Yeah, so a violation would be of the bill would be a violation under the Maryland Consumer Protection Act. And so if you go to page 4 of the fiscal note, you can see on the bottom of page 4 that penalties can be assessed. A merchant who violates the act is subject to a fine of up to $10,000 for each violation and up to $25,000 for each repetition of the same violation. So those are the statutory penalties that are applicable under the Maryland Consumer Protection Act.
Okay, thank you, Patrick.
Senator Bidle, then Senator Kramer.
Thank you, Madam Chair. So that was part of my question, but who enforces it? Like who would a constituent report this to?
The Attorney General, the Consumer Protection Division.
Thank you.
Senator Kramer.
I was just going to add, Madam Chair, that it is already passed out of the House unanimously, both in committee and on the House floor. So it's over here now. And I would move favorable on the bill as amended.
I have a motion and a second for the favorable as amended. I do have a question if you, yes, so.
Yeah, thank you. What's a rebuttable presumption? That's a term I'm not familiar with. It's on page 6. There's a rebuttable presumption that telephone solicitation made came from resident or place of business.
Yeah, so if it's if a phone call is made, for example, to, area code 301, a Maryland area code, it would be presumed that this call was being made to a resident of the state. If the party who was making the call wanted to challenge the assertion that they were dialing a Maryland resident, as a rebuttable presumption, they could come back with evidence, that would demonstrate that the person they called, in fact, was not in Maryland. But they would have to come back and rebut that presumption that the person is here because their area code is a Maryland area code.
Thanks.
Yeah. There also was a sponsor amendment. Senator Hester wanted to sign on to the bill.
Okay, so we have a motion before us, a motion and a second for the favorable as amended. We also have a request for a sponsor amendment. So are there any objections to the sponsor amendment?
Yeah.
Does anybody else want to pile on with Senator Hester? Raise your hand. Okay. It's spam. Okay, read these in one more time. Anybody that wants on this bill? Is that everyone now? Okay,
Everybody.
all right. So I have a motion and a second for a favorable as amended, as amended. All those in favor, raise your hand. Okay, that bill receives a unanimous favorable report. That bill being Senate Bill 90, favorable as amended unanimously.
Equally co-sponsored by all of us.
Equally co-sponsored by all. I'm trying to be clearer. I didn't announce some things that last time, so is everybody clear? All right, next bill.
Senate Bill 381 is a Baltimore City alcoholic beverages bill. This repeals the prohibition against the Baltimore City Board of License Commissioners issuing a Class A7 beer, wine, and liquor license in the 43rd Legislative District. It also authorizes the board to issue a Class A7 license after June 30th, 2022. No amendments.
Have a motion and a second for a favorable on Senate Bill 381. Are there any questions? All those in favor, please raise your hand. That bill receives a unanimous favorable report. Next bill.
Senate Bill 601. This is the bill that would repeal the termination date of the state-based young adult health insurance subsidy pilot program. This is the program that provides a state-funded premium subsidy to help young adults reduce the amount that they pay for health plans offered through Maryland Health Connection. The reprint here, amendments offered by the chair, would extend the termination date of the pilot for 2 years through 2025. And in addition, there's an additional reporting requirement that would have the exchange conduct a study examining the program and other options to maximize federal funding and reduce the state's uninsured rate. And these are amendments that the House is adopting as I understand it.
Senator Reedy has a question.
Madam Chair, does this change the fiscal note?
So the fiscal note is unchanged. What the program currently authorizes is up to $20 million in the Maryland Health Benefit Exchange fund to be allocated for the subsidies under this program. So that would continue for each year that the pilot program
Well,
is operated. These are special funds that come from the premium tax.
I saw that there was from special funds, but I thought the fiscal note had said it currently is 10 million and it's saying it's gonna go up to 20.
So that, I think for fiscal 2024, let's see, what is their discussion of that? So they say the fiscal 2024 budget as introduced includes 10 million for the young adult subsidy program. This reflects an anticipated decrease of 10 million over fiscal 2023 as the pilot program is intended to provide subsidies through calendar 2023 only and is set to terminate June 30th, 2024. So
But it was normally 20 million?
yes, it was.
Okay. Just curious. Thank you.
Is there any other discussion? Okay, now I'll entertain a motion.
Oh.
I have a motion from Senator Vidal and a second from Senator.
Sponsorship request from Senator Hester.
Okay. And a request for a sponsor amendment from Senator Hester.
If I'm not.
Anybody else want to be a sponsor on this one? Since we're opening the door?
I think it's one of the best bills ever.
Okay, here we go.
Yep. Try to get
Ellis.
these young people. With insurance.
Kramer, oh, go, okay. Okay. So I have a motion and a second for a favorable on Senate Bill 601 as amended with sponsors. Are there any questions? All those in favor, raise your hand. Okay, that would be 8. Those opposed, raise your hand. That would be 3. That bill receives a favorable report. Next bill.
Senate Bill 765 authorizes the Baltimore City Board of License Commissioners to exchange a Class BD7 beer, wine, and liquor license for premises located on a certain section of Frederick Avenue for a Class A7 beer, wine, and liquor license. There are no amendments to this one. 765.
Okay, so we have Senate Bill 765. We had a favorable motion and a second. Are there any questions? All those in favor of Senate Bill 765, raise your hand. That bill receives a unanimous favorable report. Next bill.
In Senate Bill 786, need to hold this, just some additional resolution is for some additional resolution on some amendments that are being prepared.
Okay, thank you, Patrick.
All right, we're going to move on to Nathan's bills.
Next bill on the list is Senate Bill 154, as shown in the reprint reflecting amendments from the sponsor, Senator Bidel. The bill requires the Department of Health to develop and implement a public awareness campaign to encourage the use of mental health advanced directives in the state. The Behavioral Health Administration and the Healthcare Commission must study how first responders and behavioral health crisis providers can access advanced directives when responding to behavioral health crises. The amendment, which is shown on page 3 of 4 of the reprint, strikes a study related to the establishment of a specified statewide database and implements the study as described. These changes to the study reflect some discussions with the Healthcare Commission and advocates.
Hey, any discussion? Senator Hershey?
Did this bring MHCC on board with it? Because their testimony had mentioned that they thought legislation last year already did this.
So the amendment was shared with MHCC and they said that they can conduct this different study and that it's not a problem.
It's different from last year.
Yes. The study has changed from the bill as introduced, yes.
Any additional discussion? I'll entertain a motion. Okay, Senator Biden moves favorable.
Second.
Senator Guile and Senator Klossmeyer second. Any discussion? All those in favor of the favorable on Senate Bill 154 as amended, raise your hand. That bill as amended receives a unanimous favorable report. Next bill.
Next bill on the list is Senate Bill 377. As amended and shown in the reprint, clarifies that certain workers' compensation benefits available to specified public sector employees are limited or offset only if the benefits are based in whole or in part on the same body part. The amendments offered by the bill's sponsor, Senator Kramer, strikes provisions from the bill related to hearing loss and tinnitus, or tinnitus, as we've heard, which began at the bottom of page 2. Further modifies provisions of the bill related to offsetting benefits as described, and that's found at the top of page 2. And specifies in uncodified language on page 4 that it is the intent of the General Assembly that the act abrogate the holding of the Supreme Court of Maryland in Spivak v. Montgomery County, and that the act be applied in a manner consistent with prior precedent articulated in Rieger v. Washington County Board of Education.
Vice Chair.
Madam Chair, I'd like to hold this bill. I have been getting all kinds of things today that are problems with it from the county and Mako. And so they're a day late and a dollar short, but I have to at least hear what they have to say.
Okay, we have a request for hold. Do you mind if we continue with discussion, Senator?
Oh, okay. Yeah.
Senator Kramer?
Yeah, thank you, Madam Chair, and I understand the hold. But Mako, which has not bothered to show for the work group meetings, either here in the Senate or the House, suddenly, yes, go ahead. Yeah, no, my understanding from all parties is Mako has been missing in action at the work group meetings on this, and that there had been negotiations between the parties that were involved. And now Mako is showing up at the 11th hour with the bill on a voting list saying, wait a minute, we were not, parties to agreeing to what was worked out, but that's because they weren't parties to the work group, which they should have been if they had an interest. So I hope we don't lose the bill and not get another opportunity to get it on a voting list by virtue of Mako's failures up till now.
Senator Klossmeyer.
Sorry. I've talked to the firemen. And so they want, I need to talk to them. They want to get a hold of them, but my own county is like going berserk on the whole thing. So I just have to at least look.
I hear you.
I want to try to fix it, and I know the bill means a lot to you, and we'll work on it.
Thank you, Senator Reedy, then Senator Hershey.
Is there an opportunity still to, if someone, did the counties not know about a work group, or was there a work group on this?
A semi-work group. It wasn't like we came in and said it was one side over here, the other side over here, meaning those that were opposed were on the left side, those that wanted the bill were on the right side. But we've never just had like 3 or 4 people together and just worked on it.
I know time is short, and I mean this, I'm not trying to be delaying, but I mean, maybe if they know, they could Mako or MML, or if there's others with issues can
Well,
come.
that's what I would like to do. but
Okay,
I
oh, yeah,
wanna
no problem.
Clear
No,
what the.
fine.
the
I heard some of the same stuff, so I just,
Yeah.
Yeah, no, I appreciate that. I thought there was already a work group that was held that they
No,
were
it
invited
wasn't a
to,
real
so,
work
no,
group. It was just
well,
what we used to do. Everybody would just state
Oh. okay.
their piece.
There, so for the, yeah, so maybe they were not included in that.
Could have been.
Okay, Senator Hershey, did you? All right, so this bill has been held. Next bill.
Next bill on the list is Senate Bill 732. As amended and reflected in the reprint. This is a departmental bill that expands the membership of the Maryland Commission on Disabilities to include an individual with a traumatic brain injury. The amendment offered by the chair at the request of the department transfers the state coordinator for autism strategy and the responsibility for providing staff to the advisory stakeholder group on autism related needs to the Department of Disabilities from the Governor's Office of Community Initiatives.
Okay, is there any discussion on this bill? Senator Biden.
Is there anything here that lays out what it is they're gonna focus on? I mean, this is just their board, right? Their commission. It doesn't say anything about their mission or.
Are you referring to the amendment that transfers the coordinator and the responsibility for staffing? Because the role of the coordinator is already in statute, but not reflected in the text of the amendment. And the same is for the stakeholder advisory group. It already exists. The amendment that the department requested is just the transfer of it and doesn't make any changes to the mission.
Okay, I may have a bill next year to look at facilities for traumatic brain injury because apparently we have none in Maryland. We'll work on it. Thank you.
Thank you. Is there any further discussion on this bill, which is Senate Bill 732? I'll entertain a motion.
Move favorable.
Have a motion and a second for a favorable on Senate Bill 732 as amended. Any questions? All those in favor, raise your hand. That bill receives a unanimous favorable report. Next bill.
The next bill is Senate Bill 839, which as amended and shown in the reprint requires that a hernia caused by repetitive trauma may be considered an occupational disease and therefore may be compensable subject to current standards related to occupational diseases. So the amendment offered by Senator Kramer strikes the bill as introduced and implements the bill as described. This is a compromise amendment developed by parties following the working meeting with Senators Klausmeier and Beidel. This precise language with the may piece is advancing in economic matters in the House.
Any questions? Senator Reedy.
What does may do to, what does that mean? This is not law I'm familiar with.
So the emphasis on the may is that originally you may have seen in the packet, there was a reprint that used the word shall.
Right.
Which after further discussions in economic matters today, there was an agreement that the shall would become may, which is a permissive standard. So instead of requiring that the hernia be treated as an occupational disease, it may be.
So before, hernias were not treated as occupational disease at all? Or-
Hernias are under a special section in workers' comp law that where it's limited to a specific incident or injury. And so the testimony that the committee received was that this type of repeated injury hernia is more in line with an occupational disease, like, for example, carpal tunnel syndrome, and can't be traced to a specific incident, accident, or injury. And that is what necessitated this additional provision, because the hernia carve out only refers to a specific incident or injury under current law.
What does this do to the opposition? There was extensive opposition on the bill. Does the amendments address most of those concerns or no?
So it was communicated to me after the meeting in the House that this change addresses all concerns.
Okay. Okay, thank you.
Thank you. Senator Mounts.
Thank you, Chairman. I think this answers all answered my questions. But just to go over it one more time, prior to this bill being introduced, hernia was not covered by workers' comp.
So hernia is covered specifically under section 9-504. That is the subject of this bill. And in that section, hernias were covered only as it pertained to an accidental personal injury or strain. And the type of hernia that is being addressed by this bill is these repeat injury type of hernias that can take years to develop that can't be traced to a specific accidental personal injury or strain. And so when it is this sort of over time injury, the bill as amended would treat that type of hernia as an occupational disease, which is a separate provision of workers' comp law.
Thank you.
Thank you. Senator Ellis.
Yeah, thank you, Madam Chair. So with the word may inserted, it will be up to, say, each workers' comp commissioner to decide if that hernia should be treated as a compensable injury.
So questions about compensability it's typically the role that the commission would play. I think that the changing shall to may was just in an effort to clarify that the bill was not requiring in every instance that a hernia caused by the result of a repetitive as a result of repetitive trauma would be considered an occupational disease.
Right.
It's just providing that additional flexibility so that those claims can be evaluated as they are under current law.
Okay, so the evaluation is done by the Workers' Compensation Commission hearing, so they would have the flexibility to determine which way to go. Okay, and so that might encourage commissioner shopping, right? You know, as far as.
No, I don't believe that would be the case.
No. Yeah.
If I understand it correctly and understand your question, Senator, I think what it means is that before, unless there was a specific accident, they could not ask for workman's comp or apply. Now they can apply for this new type of hernia that's happened as a result of recurring stress, if you will. And then they still have to present the evidence and the whatever physician information and all of that. And then the commission, which is a group that I think may be appointed.
Yes, we just appointed.
Yeah,
the new-
we appoint, they go before the commission and make their case, and the commission may now offer workman's comp for this type of injury.
Or that injured individual.
Right, right.
So how I understand workers' comp work, there's one commissioner who hears cases throughout the state. And what a problem that I've heard is that you might have lawyers making sure that do a lot of cancellations to make sure that they get the right commissioner to interpret things the way they want. And so it extends the process out as far as workers being heard and the case being decided. So I'm just kind of concerned with that word may, you know, yeah.
If you would like, I can get you someone from the Workers' Comp Commission to talk, to discuss this with you. But I don't think that's the case.
Okay.
I mean, it maybe that has happened a little bit here or there, but I don't have any
Yeah.
correlation. I've never had anybody tell me that, so.
Okay, you ever heard that? Okay, well, I'm just kind of concerned about that, but I don't want to hold up the bill with that concern. I can get the answer.
But Maureen Quinn is the acting head right now, the chair. If you would like to speak to her, she might be able to shed some light on that.
Okay,
Sounds like we need a committee briefing next session on workman's compensation.
think
I see
that
you
would
all
be a
looking
good
very
idea.
excited for that. All right. No, those are good questions. Thank you. All right, so we have before us Senate Bill 839 with amendments. I'll entertain a motion.
Oh, second.
Motion and a second for a favorable on Senate Bill 839 as amended. All those in favor, raise your hand. Okay, is that unanimous? Bill receives a unanimous favorable report as amended. That Nathan's done. Thank you very much. We'll now go to David.
Okay, if you turn your page over on the voting list, you'll see Senate Bill 404 at the top. It modifies requirements relating to a refund process that was initiated last year through legislation for patients who paid for hospital services in calendar years 2017 through 2021 and who may be determined because of this process eligible for free care. In 2000, several years ago, you passed legislation altering how reimbursement for patients who are eligible for free or reduced care can be implemented. That bill takes effect in 2021. However, from the year the bill, that legislation was passed through the effective date of the act, the commission was required to, or the hospitals were required to study and find out how many patients could have been left out of this process since the effective date of the act and when it actually took effect. And several thousand thousands were identified that could be eligible and have to go through a process to see if they are eligible for free care. The bill alters the agencies which the Health Services Cost Review Commission must coordinate in the development of the refund process and the responsibilities of those agencies, which is primarily data sharing in the bill. The bill provides a floor for the amount of paid care for the purpose of reimbursement. It lifts it up to $25 and requires the AG's Health Education and Advocacy Unit to assist these affected patients, identified affected patients. The bill also requires implementation of option 3 from the Commission's December 2022 Hospital Care Refund Process Report. And the bill would terminate on the same date as last year's bill, which would be June 30th, 2025. So the commission did submit a report based on last year's legislation, identifying several processes to reach out to these folks. And one of the options identified in this bill is option 3, which will be described, which is summarized actually in the text of the bill. There are amendments offered by the sponsor, and most of these amendments are from the Attorney General's office, the Health Education Unit. So if you go to page 2 of the reprint, you'll see that it makes this violation of that section of the law in Health General also a unfair and deceptive trade practice on page 2 of the reprint. Now we go to modifications to the existing process you established last year. And you'll see other agencies are involved because some of these agencies deal with folks who have family members who may be eligible for free or reduced or for free care if they receive services in those years. It also brings in the Health Education and Advocacy Unit by amendment as one of the entities responsible for implementing this process. Most of the changes here relating to adding these additional agencies. At the bottom, you'll see that there's more clarification of the process developed to identify these patients, including sharing tax data from the Department of Human Services, Department of Health, and the Maryland State Department of Education regarding access to SNAP, free or reduced care lunches, and also the WIC program. So if your family was and is eligible for any of those programs, you would be flagged as somebody, if they received patient care and paid for it, they could be reimbursed for the care they received. If you go to page 3 of the bill, you'll see there's each hospital is required to establish a web page to identify this process and who to contact if the patient is notified that they may be eligible for free care. There's also requirements here that the hospitals have to reimburse all the agencies involved with identifying these folks who may be eligible for free and reduced care. And now that at the bottom of the page, there's amendments to the bill. Now that the HEAU is going to be very involved with this, it specifies their role regarding assisting these patients so they can access reimbursement for the care they received those years. If you go to page 4 of the reprint, this details the requirement that they implement option 3 from the report they submitted at the end of December. If you want to read what that option is, it's summarized on lines 22 through 33. And if we go to the next page, again, this specifies that the hospitals have to reimburse the agency, so there's no fiscal note to the bill. And then there's a civil penalty added to the back of the bill if the hospitals don't meet the or comply with the bill's requirements. And finally, there's a change in the tax general article to allow data sharing for the purposes of this bill. This bill again will terminate in 2025. HGO has passed this bill already with the same amendments. And I believe as amended, there is no opposition to this bill.
Okay, you have before you Senate Bill 404 with amendments. Are there any questions?
We have a concern with sponsor. Move favorable.
Have a motion for a favorable
Second.
and a second. Are there any questions? All those in favor of the favorable, raise your hand. That bill receives a unanimous favorable report. Go to the next bill.
Okay. Yeah. The Blues Brothers. Okay, the next bill is Senate Bill 525. This bill prohibits the Department of Commerce from denying licensed cannabis business entities access to economic development and financial assistance programs solely because they are cannabis businesses. The prohibition applies to most business assistance programs administered by Commerce and the More Jobs for Maryland program. In addition, licensed cannabis businesses may also be eligible business activities under the Job Creation and One Maryland tax credit programs. There's a reprint here with some amendments from the sponsor that specify that if one of these cannabis businesses had applied under any of these programs and were denied, that they are authorized to reapply to receive benefits under these various state economic development programs. Again, Economic Matters has passed this bill. They didn't have the amendments. These were amendments offered by the sponsor, but this bill, a similar bill, is moving through the House right now.
Okay, I have a motion for a favorable
Second.
and a second. Are there any questions, any discussion on Senate Bill 525 with amendments? All those in favor of Senate Bill 525 as amended, please raise your hand. That bill receives a unanimous favorable report with amendments. We'll move to the next bill.
Okay, the next bill involves the reporting of wholesalers' information or the disclosure of their information to the comptroller. It specifies that already there's a reporting requirement in the law that says no later than 20 days after the end of each calendar quarter, or more frequently is directed by the comptroller. Each licensed cigarette wholesaler in the state shall submit information in the form determined by the comptroller to the comptroller. This specifies that this information must be complete and accurate instead of just information. The bill as introduced had a penalty provision in the back of the bill. The Attorney General's offered amendments to strike their addition of a penalty provision. So all the bill would do now is specify that the information submitted must be complete and accurate and would be subject to existing penalty provisions under the law.
I got Senator Reedy, then Vice Chair Klausmeyer.
The amendments are good. I was actually going to say, why $1,000 in criminal penalties? Why not make it a mandatory minimum sentence or something? Somebody's filled out a form inaccurately. Let's throw them away. Let's throw them in jail. So that's a good amendment, but I guess I'm confused at why we need this bill anymore. Aren't you already required to fill out a form accurately to the state? Do we need a bill?
I guess it further specifies the information and gives the opportunity. It's what the Attorney General wants.
Yeah, Madam Chair, I would move unfavorable on this very unnecessary bill. It costs money every time we do a bill.
Seems like you don't have a second.
No, I got a second from Hershey.
Yes, I did hear a motion, a second for a favorable. I did ask, though, that, I mean, unfavorable. But I did ask, guys, that before we do that, I had already indicated that Vice Chair Clausmeyer had a question, so I would ask you to just let her do that
Yeah.
before we discuss. the
I
motion.
just wanted to know if there was any opposition. Was that the one that Ruth jumped up and said,
Bruce has withdrawn his opposition because
okay.
the penalty provision is removed.
that's what I thought, okay.
I'll withdraw my motion. 541.
Senator Reedy?
I'll withdraw the motion. Can I just say, it doesn't ever hurt to kill a couple bills just to send a message that this committee can't be pushed around.
We
but,
will.
By
There's-
anybody in particular.
There's a whole lot that we could, but
Okay, I understand.
anyway. All right, I'll entertain a motion.
Move favorable.
Have a motion and a second for a favorable on Senate Bill 541 as amended. Any further discussion? All those in favor of the favorable as amended on 541, raise your hand. Okay, that's 8. And that would be 3. Are those opposed? Raise your hand. That's 3. Okay, so that bill receives a favorable as amended report on an 8-3 vote. Next bill.
Okay, the next bill is Senate Bill 562. This is creates this Maryland Small Food Banks Grant Program. It establishes the grant program to provide grants to small food banks in the state. In awarding the grants, priority must be given to entities that are nonprofit entities registered in the state, conduct assessments to track their success, and can demonstrate strong community involvement, partnerships, and with a focus on underserved communities. You have an amendment? You have an amendment, and there's a reprint. And the amendment specifies that the grants under the program may be used only to support a small food bank's operating expenses, including personnel costs. So they can't spend the money on food. Also, Senator Hester would like to be amended in as a sponsor, co-sponsor.
Yes, yes. Those, Senator Reedy has a question first before we do the co-sponsor amendments.
Just a question, how do they I didn't find a definition for small food. I'm just curious, how do we define a small food bank? And secondly, why wouldn't we want them to use the money to buy food? That's an interesting question, but. I got you. Okay, fair enough. So I would draw that question, but why, I just was curious what the definition is. I have some in my district, so I'm honestly curious.
So we can't get food with them?
No, there's other money for that.
Yes. I guess in terms of determining who is a small food bank program, when they apply for a grant, the department would make that determination. And if they didn't they wouldn't qualify for the grant otherwise.
Okay. I'm not against the bill. Just be very clear. I just think we ought to maybe could we maybe get a definition before the floor and do a floor amendment or something? I don't want to hold the bill up.
Okay.
So Senator Reedy is going to work on a floor amendment that defines, he's going to work with the chair of the budget and tax, but in its current form, we don't want to hold the bill. Is that?
No,
what
no,
I'm
we do not wanna hold the bill.
Okay, we don't want to
No,
hold
ma'am.
this bill that gets
Here.
food to
The
our,
sponsor is a thoughtful and caring legislator.
and it's a good cause.
It is.
Who doesn't have a food bank in there? Okay, so, Vice Chair, do you have a question?
Yes, I would like to be a sponsor.
Okay, let's see the hands of everyone that would like to co-sponsor this bill that helps Maryland Small Food Bank get grants.
Okay, entire committee.
Is that Senator Hayes? You don't want to? That's, okay, that's everyone as co-sponsors on Senate Bill 562 as amended. So I'll entertain a motion on the bill as amended.
Move favorable.
Have a motion and a second for Senate Bill 562 as amended. All those in favor, raise your hand. That's consistent with the sponsor list. That's a unanimous favorable report. We can move to the next bill.
Okay. The next bill is Senate Bill 574. It increases the time that a state employee in the executive branch or an applicant for employment in an executive branch agency may file a complaint alleging that political affiliation, belief, opinion, or other non-merit factors were used in an employment decision. The bill also expressly allows a state employee in the executive branch or an applicant to file a complaint that alleges harassment as defined under Title 20 of the state government article by an employer and requires the complaint to be filed within 2 years, consistent with Title 20, after an alleged violation that is the basis for the complaint. So what the bill does in its simplest is state employees can do this right now. If they feel they've been harassed, they can file a complaint either under state law, or they can go to the Commission on Humans. What's that commission called? Anyway, the commission that oversees employment discrimination statewide, they can go there and file a complaint. This allows them to file the same complaint for harassment with the under state law. And the timeframes for the 2 years are consistent with the violation under Title 20. And also it allows them to increases the time frame for filing a complaint under state law regarding discrimination.
Senator Mounts.
Does the bill cover at-will employees?
Yes, it does. You can, an at-will employee serves at the pleasure, but they are also covered by, you can't discriminate against an at-will employee. So anything relating to discrimination or harassment would still fall, would cover an at-will employee.
Any other questions? Discussion, motion? Okay, I have a motion and a second for a favorable on Senate Bill 574. Are there amendments?
No, there's no amendment.
Without amendments, at 574 is before us. All those in favor of 574, raise your hand. That bill receives a unanimous favorable report. Next bill.
Senate Bill 608 generally codifies the Maryland Statewide Independent Living Council, which was created by an executive order in 1993 in accordance with the Federal Rehabilitation Act. A board of directors for the council is also established to manage the council's miscellaneous provisions. You have amendments, you have a reprint in front of you with amendments. And the amendments make the bill identical to House Bill 53, which is already here in finance. The amendments strike the board of directors, add a role for centers of independent living, and specifies a process for dealing with council vacancies, and deletes a requirement for a seal.
Hey, is there any discussion, any questions? Senator Ellis.
So delete the requirements for a seal?
A seal, yes.
Is that? Okay. Is it like the state seal crest or? I'm not sure.
I guess when they drafted the bill, it said the council may adopt a seal. There's probably a fiscal note associated with developing a seal, so by removing that, you would.
The crest, yeah. Thank you.
All right, are there any additional questions or background sounds or? Okay. You have before you Senate Bill 608 as amended. I will entertain a motion.
Move favorable.
Have a motion and a second for a favorable on Senate Bill 608 as amended. Any questions? All those in favor of the favorable with amendments, raise your hand.
Yeah, that was that.
Okay, that bill receives a unanimous favorable with amendments report.
I think I ran.
Next bill.
Okay, we're on Senate Bill 828. And if you recall last year, you all passed the Family and Medical Leave Insurance Program. I'll use family for short. And the bill is now enacted, and the process has begun for the department to implement the bill, but obviously there was a pretty aggressive time frame in the bill. So you have a bill here to make modifications to the program. And first off, the bill extends the dates of family implementation in several instances. Most of these dates are relating to the time when benefits can start, or when you start taking contributions, and also when benefits are being paid. And there's several dates involved with that, and all those dates are extended. The bill also makes corrections because of the extensions and restores some of the language changed by the House that was sent over by the Senate. It also clarifies confusing language and adds language for the purpose of allowing private insurance participants. They're already authorized to participate in the program, but there's language here that would make it easier for them to sell plans so people could access these private plans instead of participating in the state program. You have a reprint in front of you because there's always changes. So we'll start with page 2. And some of these changes, again, are clarifying in nature and designed to make the program easier to implement and understand. So you'll see that there's a change here for application year. This clarifies the definition of application year on page 2. If you go to page 3, you'll see that family members is amended to include a domestic partner because almost all the states in the union who have these programs also cover domestic partners. Let's skip to page 5. There was no definition of wages in the original law. A definition is added here, but it's amended, and the definition is primary. It was added to at the urging of the private insurers. It makes it easier for them to participate in the program for people to buy these plans. Let's see, we go to page number 6 at the bottom. And there's language here clarifying the process. Right now, you can use benefits for the birth of a child and the placement of a child. This clarifies the language regarding the placement of a child. If you go to page 7 at the bottom, you'll see that there's the duties of the secretary are identified here, and including procedures, establishing procedures for notifying an employer. The bill changed it to 3 business days. That is amended out back to 5 business days at the request of the department to give them ample time to process these applications. Also, it specifies what is meant by claim for benefits. That was just saying, in the bill last year, it just said claims for benefits, or in the law right now. This specifies what all these types of claims for benefits can entail. That's at the bottom of the page. If you go to page 8, there's language added that specifies that clarifies when leave starts and the duration of the leave. If you go to the bottom of the page, there was an amendment and there was a change to the bill specifying what was meant by a serious health condition. That is struck by an amendment, and you're back to the original language about a covered individual who can get benefits for a serious health condition. So you're back to the original language here. You go to page 9 at the top, you'll see frequency is added. This is clarifying regarding the duration of the leave. Again, the change on lines 3 through 7 on page 9 take you back to the original language regarding a serious health condition. At the bottom, there's expanded reporting requirements for the department regarding folks who are reporting on how the report is doing. That takes you through to page 11. And you'll see that the reporting requirements that are established here do not apply to an employer that has a private employer plan, which is described later on the bill and authorized later on in the bill. If you go to page 12, the top of the page makes a change to the process of issuing the checks. At the urging, the treasurer would like it be clarified that his name doesn't have to appear on the checks. So that's what these changes do right here. That's clarifying. Now we get to the part of the bill where everything is really pushed back. The bill has introduced, pushed back the collection of benefit or collection of contributions from January 1st to October 1st, 2024. So all these changes where it's moved back 6 months or a year are at their suggestion of the department. So they can take their time and get this program right. Also, you'll see after line 12 on page 12 that there was no cap on the total contribution. That is restored here by amendment. These are all from the sponsor, by the way. So the total contribution established under this section, regardless of how they're calculated, can't exceed 1.2% of the employee wages, and it will apply it up to all wages up to and including the Social Security wage base. So this provision came out of the Senate last year, although the cap was lower, but the Senate did pass a cap on contributions last year, which was struck by the House. But the cap on contributions is now back with this amendment. Again, you'll see going down here that all the dates are pushed back regarding the role of the secretary and how they're supposed to calculate the contributions, which can't exceed, again, 1.25%. There has to the first round of contributions are based on existing studies, but if you go further down on the page, you'll see eventually every year the secretary is going to have to do a study to determine what the contribution rates are going to be, and they should be reported to the General Assembly. If you go through page 13, that they will have to report this information to you. And most of this language on page 13 involves the calculation of how of what the contribution rate should be. Now, if you go to the bottom of page 13 through the next, last year, the law requires that employers with 15 or more will contribute. But if you're an employer under 14 or under, you do not have to contribute to the fund, but your employees will have to contribute. So because of the changes here, all that was struck. And instead you specify here in new language that the employers with 15 or more have to contribute, and but all employees would have to contribute. And if you go on further down up on top of page 14, you'll see that there's an amendment here that each employee has to contribute 50% of the contribution, and the employer has to contribute 50% of the contribution. If you're an employee working for an employer who is not doesn't have to contribute, you still would have to contribute the equivalent of only 50% of the total contribution. So they wouldn't be required to contribute all of that. They would only have to contribute what all the other employees would be required to contribute in terms of a percentage. In the middle of page 14, last year you authorized an employer to, at their option, to pay more than the requirement for the employee contribution, so they could cover it all if they wanted. So this modifies that language slightly to say, and I would say this is clarifying, an employer may elect to pay all or a portion of the required employee contributions. They would have to notify the employee that they're doing so, but the employer does have the option of paying more, but they obviously can't force the employee to pay more. If you go through to the bottom of the page, there was language that was in last year's bill, an uncodified language. It was the intent of the General Assembly to, if you were making under $15 an hour, you would have to, the General Assembly may wish to consider paying the employee's share of the cost. And there was also language this, it was the intent of the General Assembly that they pay certain community providers for the employer's share of the cost. With the minimum wage bill moving through the General Assembly, that requirement, this bill would have codified those requirements. With the minimum wage bill moving through the General Assembly, and there will be I've adjusted the amendment to make additional changes, but you'll see that you're striking the language in the bills introduced regarding covering the employee's share for the community providers. And on top of page 15, this is going to be struck regarding covering the employee's share if you make under $15 an hour, because by the time contributions are set and this process is underway, if the minimum wage bill passes, all the employees will be making $15 an hour, so it'll be moot. Instead of the language in the bill is introduced regarding the employer's share, if you're a community provider, there's an amendment here which further specifies and is more technically accurate regarding the coverage of community providers who are licensed as under the laws governing developmental disabilities and behavioral health providers. So these folks would be, their employer share would be covered under here with a combination of state and federal revenues. If you go to the bottom of the page, again, you'll see more dates being pushed back at the urging of the department so to allow them to further be able to implement the program. And then there's a change here on bottom of 15. This is consistent with what you did earlier regarding the placement of a child. This is the same language here. And again, regarding the serious health condition, that also is altered at the bottom of page 15, where you're back to the original language regarding being able to use benefits as a serious health condition. And on page 16, there was some testimony. This is where the employer notification is provided for in the bill. You'll see that except that this is existing law, nothing has changed here, except as provided under subparagraph 2. If the need for leave is foreseeable, an employer may require a covered employee taking the leave under his title to provide the employer with written notice of a covered employee's intention to take at least 30 days before the leave. Obviously, if it's not foreseeable, the leave should be as soon as practicable. On page 17, this specifies the time period for filing a claim for benefits at least 60 days before the anticipated start of the date of leave if it's known, or no later than 60 days after if it's not anticipated. The department requested this time frame to allow them ample time to get the processes and the procedures underway. And just as a note that while this is ongoing, you are not entitled to getting paid for benefits. You have to be approved by the department. So the idea here is they would probably try to get this done as soon as possible. If you go to the bottom of the page, this concerns the limits on the receipt of benefits. And there's no change to what was passed last year at the bottom here regarding 12 weeks, but you can get an additional 12 weeks. One, if you took leave because of pregnancy or the placement of a child and you got sick later, you could get an additional 12 weeks. That's one circumstance. And the only other circumstance under existing law to get an additional 12 weeks if you were sick and then subsequently for the birth of a child or the placement of a child. Those are the only two circumstances when you can go under existing law and an additional 12 weeks of benefits. On page 18, line 7 through 9 was struck originally. The brackets, you can't see it here, but the brackets are struck. So the leave has to be used concurrently with the Family Medical Leave Act. It specifies here that if you take leave under this program, you would have to use it concurrently with Family Medical Leave Act. And then there's language added after that, which specifies, and there's some amendments here, but the purpose of this new language here is to say that if an employee wants to take Family Medical Leave Act first, that they would not be allowed to if these circumstances apply. So this basically makes it clear that if the employer can decline an employee or prohibit an employee from taking family medical leave first and then coming back and taking paid benefits under this bill. So that's the intent of lines 10 through 18. And let's see if we go further down here. Oh, there was language last year that the House put in that prohibited, that would require all employers to, require an employer to require their employees to exhaust all leave before taking benefits under this program. That is struck, and now it says here that an employee may not be required to use or exhaust paid vacation, paid sick leave, or other paid time off under an employee policy or while receiving benefits under his title. However, if you go in the bottom, if they can make an agreement with their employer to use this time and get reimbursed up to 100% of their average weekly wage. Under the bill, if you just took the leave, you wouldn't obviously get full wage replacement, you'd get less. But you can make an arrangement with your employer, and using your current paid leave you have available, you could get up to 100% of your weekly wage for a certain period until you exhaust your paid leave. If you go to page 19, There's new language at the top that again clarifies the previous things we were just talking about exhausting leave. And if you go to the bottom of the page, this is the language, this is existing language about what you get covered, if you want to get into those details again. How much you can get paid while you're on leave. That's obviously income based. And if you go to page, the bottom of page 19 to page 20, there was an allowance for intermittent leave that is struck, and instead it's replaced with the language on lines 10 through 12, which gives the option for it allows the department to determine how much you would get reimbursed on a weekly basis if you were taking part-time or intermittent leave, as long as it doesn't exceed more than 100% of the covered individual's average weekly wage. So the department would determine the reimbursement rate for part-time or intermittent leave under this program. More dates are pushed back, as you can see on the bottom, again, to allow the department time to get this program up and running. If you go to page 21, let's see, what are we doing here? This concerns part-time leave, and again, it specifies that the department will determine the benefits paid for part-time leave under the program. If you want to take your leave in increments or part-time, or you're a part-time employee. At the bottom of the page, again, there's a language here regarding notification of employers, and it takes you back to 5 business days from 3, which was suggested by the department, so you would be consistent there. Go to page 22 of the reprint. More dates are pushed back to allow for implementation of the program. And at the bottom of the page, this is the language that was in last year's bill that authorized an employer, if they wish, they could get their own plan from a private insurer instead of participating in the program. This further clarifies those that authorization if you wanted to use that to provide your employees with this benefit through a private insurer rather than a state, as long as the plan is at least as generous as what is provided by the state. And the Maryland Insurance Commissioner wanted a language here saying that these folks had a certificate of authority from the Maryland Commissioner, meaning they're eligible to do business in the state. Otherwise, they couldn't offer these plans. And let's see, onto the top of page 23, this all has to do with allowing these private plans and clarifying the circumstances under which they can operate. And let's go to page 24. There's language here adding more specificity regarding the appeals process if somebody's been denied benefits. And at the bottom of the page through the next page, these are all clarifying change. These are all changes necessary to reflect the fact that you're pushing the program back. There was a lot of requirements that were put in uncodified language last year. Those are struck because now you can codify everything because you've given the department enough time to get this process of calculating benefits, calculating contributions in place without having to go through uncodified language. And on the middle of page 25, initially, the repeal of the covering the employees' contributions under minimum wage was going to be dealt with here. But now again, since you're pushing everything back another year and, possibly the minimum wage will be $15 by the beginning of next year. By repealing it in the law, it's a cleaner way of doing it than doing it this right, repealing that requirement here in the back of the bill. So that would be technical. This is going to be struck in the final version. And then the department wanted a specific requirement that they have regulations in place by January 1st, 2024. So these are corrections to the existing law. And these are all amendments from the sponsor who worked really hard on all these.
I have a question from Senator Kramer and then the Vice Chair and then Senator Vital.
So thank you, Madam Chair. So here's what I'm trying to get a handle on: the nonprofits. And maybe you all have received this as well. I've gotten numerous emails expressing concern about that portion of the language that removes the language that disallows employers from requiring employees to exhaust employer provided leave before taking the insurance leave. Was any consideration given to how this impacts the nonprofits? They seem to be indicating that they have tremendous amount of difficulty finding employees as it is, and that trying to fill in these gaps are going to be problematic, and they're going to be left without adequate coverage in what they do.
No, nobody, they didn't approach anybody. There was no amendments submitted, and I don't know if they contacted the sponsor about their concerns.
I'm the only one who's been getting all of these emails. Is that? I don't know. I mean, it sounds like they've got a viable concern. I'm surprised that I'm the only one who seems to be. Reading further from one of the emails, this could result in employees taking 3 to 6 months off for qualifying conditions, and then additional time off for vacations and other reasons. And they're just indicating that could make their staffing and services exceedingly problematic.
I mean, Senator, I'm looking at the testimony submitted to the committee. I see 78 pieces of testimony, and I think I see 3 or 4 unfavorables, and at least 3 of them are from chambers of commerce. So
I'm the only one who's been getting emails from nonprofits.
I don't.
With concerns. Well, I guess then my job here right now, right here, is to be expressing the concerns that they have forwarded to me. Is there a possibility of addressing their specific concerns and providing them with an avenue for assistance? Can we have that conversation?
What was their concern? Can you repeat it, please?
Their concern is that by reversing what we did last year with regard to the requirement that the benefits had to be exhausted before they could qualify for this, is going to leave them in a very difficult position, because they're already finding it very difficult to find employees in these nonprofits, jobs that they are providing. And so they were, I guess, looking for some kind of relief that it requires a commitment from, the work that they do. God bless them, they're doing the Lord's work, but it's hard to find people to fill those positions. So.
Okay, I don't know if I have like 5 people in queue. I didn't know if the sponsor, if you were wanted to respond to that.
I think the amendment that the House put in there last year, that you had to exhaust all of your leave, I'm not sure if I agree with the way they interpret it. It seems like the way the amendment was drafted, it would give them an even longer period of time, because they would have to exhaust all of their leave, and then you would tack another 12 months on top of that. So 12 weeks on top of that. So I'm not sure if they are interpreting the changes that we've made accurately.
Well, I'm assuming their point is, if there is something qualifying, that the person who qualifies under the requirements for the insurance will take that leave and then subsequently take all the benefit time that they have accrued, as opposed to if they have to put their accrued leave towards that, then, you know, they would be utilizing that time in the balance. So I'm just looking to see if we can help the nonprofits
And
here
was this from
who
is this from the Maryland nonprofit?
it was just a
Was it
bunch of different
specific nonprofits?
organizations.
Okay.
Let me just say, I think the way that the sponsor was just explaining it is correct. And I think this way with this amendment, it gives the employee the option of using this family leave first and maintaining their leave for which they get a 100% reimbursement.
Mhm.
And so I think it actually, they can still use both. But this says they don't have to exhaust their personally accrued leave.
I understand, and I think
Yeah.
that's the point they're making.
Yeah.
Is that rather than using some of that accrued leave toward this issue, they'll find themselves having to try to fill the gap with employees in a very difficult workplace in these nonprofits, which is already challenging based on the pay scale and the requirements that and the services they provide to people.
No, understood.
it's tough on them.
Every business is having to grapple with that.
No, I understand,
And,
but these nonprofits do a lot for folks that
The other point that I would
Understood.
make is one of the other changes that we've made is that the insurance is concurrent with the FMLA, which provides you the job
and I
protection.
saw that, but
And once that's exhausted, you don't have the protection that you had. And that's one of the biggest arguments from last year that it didn't run concurrently together.
absolutely, no, just wanted to point that out.
Thank you. I've got Vice Chair Klausmeyer, Senator Bidle, Senator Guile.
David, I'm just a little confused on page 6. There's it says procedures for notifying an employee within 5 business days. Okay. And then back on page 17, it says 60 days. What does that refer to? What do those two things refer to?
The 5 days is the time that the department has to notify the employer. The 60 days gives the department the time they need to process the request for benefits.
Okay, now suppose I fall and break my leg. I don't have 60 days to do that.
Well, there's again, as envisioned by the bill, there's two types, there's two circumstances where you get leave. Planned leave, which you know you're going to be out for a while for whatever reason, surgery or take care of somebody. Unplanned leave where you fall and break your leg and you have to
Okay.
come out. So that's where the 60 days beyond the time when you started taking the benefits come into play, but it can't go beyond 60 days.
Okay, then on page 12 at the top, it says paid employees, 25% paid employees, and then 25% paid employers, and then 75. Just explain that to me.
We're top of page 12.
13.
That's
13.
all struck. That's all struck.
Oh, that's all struck.
That was
Okay.
put in that was put in last year.
Okay,
And the idea was to,
all right, I didn't realize. that.
yeah, as envisioned by the House, they created a range instead of specifying who pays what. They had a range that would be determined by the department. It could be 75-25 or 25-75. It was left to the department. This
Okay.
says, as amended, 50-50.
Okay, now, one other thing, I just want to ask Senator Kramer one question. You're talking about the nonprofits, but there's so many different kind of nonprofits, I would say. Are you referring to one specific type of the ones that take care of patients, those kind of?
Well, I think it's kind of a fairly broad range of services that they are
Right.
providing. And
Because like a hospital is a nonprofit, isn't it?
well, I don't know whether that would necessarily be, but
Yeah, I just wanted to ask him a question before and I couldn't, so Okay,
No, I think some of these are that provide behavioral health services and others that are providing assistance to folks with developmental disabilities and
okay,
so,
that's what I'm worried about.
yeah.
Okay. Lost my place, but I wrote it down. Senator Bidle.
Thank you, Madam Chair. I'm still a little confused, David. The bottom of page 11, we start, no, I'm sorry, you're page 12, where you marked it page 12. 75% paid by employers and 25% paid by employees, right? That's still in the bill, right?
That is struck. There's brackets, it's
There's
bracketed out,
brackets.
yes.
Okay, so now it's 50-50. I didn't
It's
see the
now, yeah, I'm
brackets.
sorry, I mean,
Okay, that's
it's,
okay. I also wondered when we talk about an employer can buy their own plan, is there any guardrails on the cost? I mean, you can buy your own plan and have it be more than the state plan, that you'd be requiring the employee to pay more than they would pay is, so are there any guardrails?
not, no, because you have an option. You can either participate in a state employee and pay whatever your contribution is, but you allowed these employers to, you allowed these insurers last year to give this option. So I would imagine they would want to be competitive, or why would you do that?
They'd be paying more too. The
Yeah.
employer would
Well,
be
that's
paying
true. My other question was, I had an amendment last year, and I know it got in the bill about if you were the sole employee of your own business. Is it still?
That's
in-
all maintained. All
That's
that
all
is
maintained.
maintained, yes.
Thank you.
Thank you. Senator Guile.
Thank you, Madam Chair. David, for the notice requirements, just so I understand it, so it says on page 16 that an employee has to give notice to the employer as soon as practicable. But as far as applying for the benefits, it has to be 60 days before the anticipated leave, but not later than 60 days after the start of the leave. I guess the one thing I'm thinking about too is like, okay, I get that, you know, if a person's on leave, if they're an hourly employee, they're not getting paid, but if there's a salary employee, like what does the employer have to do? They have to continue paying them during that 60-day time period? Is there a guarantee that they keep their job open to them? Like, it just doesn't seem to be a little bit of, I don't know, or at least as I'm interpreting it as some lack of clarity, what that time period is supposed to be for the employer.
If they're on leave if they're on leave and they're taking leave under this program, but they don't have approval yet and they're not getting income replacement from the program, then I don't think they would be getting, there's no obligation for the employer to pay them, so they would not be getting paid. So you would think that this would try to be resolved as soon as possible so they could get income replacement under the program.
And there's no requirement like FMLA does, like keep their job open to them.
There is
or-
requirements in last year's bill that they have to come back to the position that, or equivalent position that they left while they were on the benefit. Or they
Okay,
were taking benefits. Yeah, so there is, you can't just, you have to take somebody back.
yeah. And is there any requirement by the department to like a time period by which that they have to respond to an application?
Well, that's what's specified in the 60 days before and the 60 days after. They have this much time to process the application, and that was requested by the department. And I'm losing track of what page that was on.
Well, there's 17, but I read it as an individual may file an application for benefits. But once they file, doesn't the department have to make a determination if they're eligible, like when the determination comes out?
Yes, they have to make a determination, and they should try, I would imagine they would try to do that as quickly as possible. So, okay, yes, 60 days before and anticipate and yeah, so they have to do everything within 60 days.
Okay,
And during that period, if they're actually out, then the employee's not getting paid. They're not getting income replacement.
right. No, I understand that. I guess I just read it as an individual may file an application. I just read it as filing, not necessarily when the determination is going to be made by a department of eligibility, but all right. Thank you. Those are all the questions I have. Thank you, David.
Thank you. I don't see any additional questions. Hmm?
What do you want to do?
Entertain a motion? Okay, I have a motion and a hesitant second for a favorable on Senate Bill 828 as amended. Any further questions or discussion? All in favor of 828 as amended, please raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. That's 8. Affirmative. Those opposed, raise your hand. Thank you. That's 3. So that bill receives a favorable 8-3.
That's
Next,
it.
that's the last
There's no
one.
more.
Oh, we do. We
I got
do
two
have
draws.
others. We have lost it somewhere on my paper. Okay, we have Senate Bill 575 and Senate Bill 688 have been withdrawn by the sponsors. Is there a motion for the favorable, unfavorable?
Motion to have an unfavorable for
Oh,
both of them.
Okay, and a second. All those in favor of the unfavorable withdrawn, please raise your hand. Unanimous. Thank you, guys. Hard work today. Appreciate you. Get some rest. Yes, ma'am.